Good afternoon. Thank you for joining us this afternoon. Up now, we have intellectual property protections available for toy products. The session is being presented by Joshua Harrison. Joshua?
Thank you. Hi, everyone. I'm Joshua Harrison, and I'm a lawyer from California. But don't get up and leave. There's probably some other reasons you can still want to listen to me. One is I'm also an engineer. I was an engineer before I became a lawyer. I had a long engineering career. I worked in industry, and I even taught engineering at a major university, so it might be worth listening to. Today, I'm going to be talking about the law, though. I'll be talking about some legal concepts, specifically intellectual property law concepts and as they apply to the toy industry. Now, back when I was an engineer, I didn't put disclaimers on everything, but I do now. So you'll see, even on my very first slide, I have a disclaimer at the bottom. It says, "This is not legal advice, and it is not intended to be complete or reliable. I am not your lawyer, and you are not my client." So I wrote that because we're really just going to be talking about general legal concepts, and I don't want, it's like a price of admission is you guys all have to promise that you're not going to sue me 5 years from now or 3 years from now and say, "I would have made millions of dollars if you had described this differently on that one day." So is that fair? Okay. Let's see if I can advance this slide. There we go. So what are we going to talk about today? We're going to start off by talking about how the toy industry is different from other industries from the viewpoint of intellectual property. As you might imagine, although all intellectual property laws apply to the toy industry, intellectual properties laws were not written with the toy industry specifically in mind. Some patent law concepts were written seemingly with the pharmaceutical company particularly in mind, but I guess the toy industry doesn't have that kind of lobbying money. So there are some rough edges where the laws don't fit quite as well to the toy industry, and we'll talk about those. And then we'll get into the types of intellectual property law that apply to the toy industry, and we'll talk about those, but then thereafter, because I'm a patent attorney, we're going to start focusing in on patent law, and we'll talk about what types of product features are patentable, who should be listed as a co-inventor on a patent, why prior art searching is very, very important, and what rights patents confer and to whom. So, what's different about the toy industry? I noticed immediately when I started representing toy industry clients that the toy industry does one thing that some other industries go out of their way not to do, and that is unsolicited ideas from the public. So I used to be in-house with a disk drive manufacturer, Western Digital, and we made sure no one could tell us their ideas, because the chance that a person on the street would have an idea that would actually improve a disk drive was very low. But the chance that they would later sue the company and say, "No, that thing you're doing, that was my idea, I told you about that," was a lot higher. So they didn't want your ideas. However, the toy industry is different. Almost all the big toy manufacturers solicit and have programs for small inventors to submit ideas. And when that happens, there needs to be legal protections for both parties. Another difference with the toy industry is that products can have very short lifetimes, but not in terms of wearing out necessarily, or they're disposable products. It's just that people want to go on to the next best toy. And so sometimes, say something's hot in one Christmas, and then the next Christmas, no one wants it anymore. And because of that market-imposed obsolescence, it can give opportunities to counterfeiters and unlicensed manufacturers and knockoff suppliers, because by the time that you assert your intellectual property rights, courts are slow. They're sure, but they're slow. And you know, it can be the case that that entity is no longer even infringing. Nobody even wants to buy that product anymore. And the most you can sue them for is damages, and maybe they don't even exist. So it takes time to bring a judgment against somebody, and sometimes there's not enough time available. And the last thing that's different for the toy industry relative to some other industries, but not all, there are industries where a lot of players are small. Toy industry is one of them. So there's other industries, say, where almost all the companies are large. I mentioned the pharmaceutical company before. Though companies like that, in order to even get through clinical trials and so forth, you need a lot of firepower, engineering, development, R&D resources. And so there really aren't small players in that industry. Or, say, selling automobiles. It's difficult to break in. Elon Musk managed it, but most people can't. But with the toy industry, it is possible for there to be a lot of small inventors and people that come up with great toy ideas. And so the toy industry is in that category. And that affects intellectual property, as we'll get into as we go through. So, types of intellectual property that are applicable to the toy industry and other industries. We have patents. Now, I don't have anything on this slide about patents because most of the remaining slides in this presentation are about patents. Not all of them, but most of them. We have trade secrets, which is like a patent, except with a longer term, without having to publish it, and you have to keep it confidential. We'll get into trade secrets later in one of the last slides as an alternative to patents. And then we have these two other areas of intellectual property law here, trademarks and copyrights. And a lot of people don't understand the difference between the different types of intellectual property. They're not all applicable to the same things. And I've heard a lot of lay people just say, well, we'll get a patent or a trademark on that. It's like, trademarks are very different. So patents are focused on a new, novel, non-obvious idea. Trademarks are focused on avoiding customer confusion on goodwill that's built up in an industry based on advertising and the use of a mark, a trademark, or a service mark in commerce. So those are two completely different concepts. So what trademarks do is they identify a source of goods or services, and they protect a company's reputation or the investment they've made into generating goodwill amongst the consuming public. Whereas patents are established by, convincing patent examiner and later a court that an idea is yours. Trademarks are established merely by being the first one to use a particular service mark in commerce. And I put this last bullet, the last two bullets. So a lot of people don't understand this. I would say that the most important thing for a takeaway for people in any industry, including the toy industry, to understand about trademarks is that there's always a tension between what, say, my clients want their trademark to be and what's allowable. For example, what most entrepreneurs want their trademark to be, or you want it to describe your product. So you want your trademark to be, to kind of let people know what your product is. But it's important for your trademark actually not to be descriptive of your product, because a descriptive trademark is a weak trademark. In fact, if it's only descriptive, it's actually an unenforceable trademark. because what you can't do is take words that are already in the public domain out of the public domain. As a matter of public policy, you can't just say, well, look, a good example would be Apple Computer. Apple Computer is a decent trademark. It's not the strongest trademark in the world, but it's not completely descriptive. Now, if you had, imagine you were selling fruit, and you were selling apples, and you tried to trademark Apple on the Apple Fruit Company, then everyone else out there who wants to sell apples wouldn't be able to use the word apple to describe their product because you'd have the trademark on apple. You can see that doesn't work, and that's the limitation. So that's why you're not allowed to trademark something that's descriptive of the actual product. You can't take words out of the English language. So if you were selling plush toys, you can't say, well, we're a plush toy company. Our trademark is plush toys. Can't do it. So now, copyrights. Copyrights are immediately attached to works of authorship. So and trademarks, by the way, let me go back to trademarks for a second. Trademarks and copyrights do apply to toys. They just apply differently. Whereas if a toy has a new, useful idea, non-obvious idea in it, you can patent it. But it might be the case that the toy, say, looks a lot like an action, it's an action figure and it looks a lot like a movie character. Now, those movie characters are obviously copyrighted by entertainment companies. And so in that case, you may have made that toy the same way everyone's always made those toys. There might be no new, non-obvious invention involved, but if you get a license to the copyright, no one else can make that toy. Not because you had a new idea, just because you licensed it from the entertainment company. That can be true for, let's see, basically any, kind of, whether it could be a book, it could, start off as a book and then end up as a movie and then end up as a toy. It doesn't matter. But one of the great things about copyright is the duration of copyright. I was mentioning that patent laws seem to have been influenced very heavily by pharmaceutical lobbying. Copyright was very influenced by Disney lobbyists. So the length of a copyright now is 70 years plus the author's life. It's a really, really long term. Patents only last 20 years from the date of filing. So I would like to have, as a patent attorney, I would like to have gotten the kind of treatment that Disney got. But now, at the bottom line is, if you can get a product protected by copyright, it'll be protected for a long, 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 long time. So now, after the presentation, if you have any questions about copyright or trademark, I'll be right over there on the Ask a Pro desk. But I'm going to start moving the presentation now to focus more on patent law, which is most of my practice. As you might imagine, I'm an engineer, so my highest and best use is patent law, usually. So what is a patent? There's a thing called the patent bargain. The patent bargain is if you disclose your new idea to the public, because you don't have to, but in return for doing so, if you do it, the U.S. government or any other government, it's very territorial. U.S. patents are only enforceable in the United States, and Australian patents only in Australia, and British patents only in England. But in our case, the U.S. government will give you a limited term monopoly in exchange for your willingness to disclose your new idea to the public. You'll be allowed to have exclusive rights to that idea for 20 years, and then the whole public can use your idea from thereafter. So that's the bargain. It's in order to incentivize people to disclose their new ideas to everyone else. Those patent applications aren't immediately disclosed. So usually, if you want to keep your invention secret, you can still apply for the patent. You still will ultimately have to disclose your idea to the public, but you will have a year and a half of confidentiality. Now, if you agree to never file in a foreign jurisdiction, you can have confidentiality all the way up until the patent issues, which might be 2-3 years later, but ultimately you will have to disclose it as part of the patent bargain. And we're going to get into what alternatives to patents there are. The 3 types of US patents and the main parts of a utility patent. So, the source for authority for the patent goes all the way back to the United States Constitution, Article 1, Section 8, to promote the useful arts and sciences. And we talked about what the incentive is. The incentive is you get this limited term, some people say a limited term monopoly, but it's not really a right to a monopoly at all. See, your patent rights might only cover one little aspect of a product. And it might even be small evolutionary improvement. That doesn't really mean you're going to have a monopoly. People are going to be able to compete against you. But what you'll have is you'll have an exclusive right. You'll have the right to exclude others from using that one little, possibly little, feature that you patented. And that exclusive right actually can be dubious for small inventors also because it's not free. It's not self-enforcing. You have to assert the patent in court, and that's expensive. A lot of people don't understand it, but your own patent doesn't give you a right to make what you patented. So if you said, let's say you made a really great invention. Say you invented the bicycle. You were the first person to ever come up with the idea to invent the bicycle. That would be an amazing invention. I mean, God was a genius, whoever did do it, right? So let's say your patent claim is really strong, it's really broad. It just says anything with 2 wheels, pedals, and a handlebar and a seat, that's mine. You're not allowed to make it. And your patent gets issued. You're going to make a lot of money. But you can't make a bicycle because some other guy has the patent on the wheel. And your bicycle needs a wheel. So because your bicycle uses the wheel, you have to license the rights to the wheel. Is that correct? Oh my gosh, I better go much faster. So anyway, you'd have to license the wheel in order to sell your bicycle. I think I need to go a lot faster. Most of the patents involved in the toy industry are going to be utility patents. There's design patents and plant patents as well. The types of inventions that are patentable are going to be subject to a number of limitations. They have to be new, which means novel, and non-obvious, which means based on, your idea would not have been obvious to somebody who's already skilled in the art that's whatever aspect that you're inventing is. We can talk about what's in a utility patent. You've probably seen them. The main thing to understand is that the claims define the right, the exclusive right, and the written description and the drawings are there to support the claims. There are limitations on what's enforceable when you don't have enough support in the claims. This is a big one, and I'll cover it quickly. It's not like a scientific paper. Only people who were involved in the original conception or the original idea should be listed on a patent, not everyone who contributed. If they contributed under the direction of an inventor, but their contribution was just routine work, then they're not an inventor and they shouldn't be on there. It's important to when you write a claim, You need to know what's been done out there. So you do a prior art search. You can only claim the difference between your invention and what other people have published or sold before. I talked about the exclusive right and the fact that it doesn't give you a right to use. I talked about the fact that patents are territorially limited. I talked about confidentiality. And now trade secrets, they have an unlimited term, but you need to keep your invention secret if you're going to go that route. So for example, if you have an invention that you don't want to disclose to the public, per the patent bargain that I talked about, you can keep it secret and still profit from it. But, and you can do that forever. But if it's reverse engineerable, then you should file the patent. Because once you sell the product, if it can be reverse engineered, your secret is out. But if you think that it's a manufacturing idea and you can keep it secret forever, the trade secret's the way to go, and it lasts forever. And if you have any questions, I'll be at the pro desk after this presentation. I had to kind of rush through the back half of it because I lost track of time. Thank you very much.